We're joined now by Brad Jacob, the Associate Dean for Online Programs at the Regent University School of Law. Professor Jacob, thanks for being with us.
My pleasure, Wendy.
Well, you've been following both of these cases. Let's talk first about Little Sisters of the Poor. How important is their win for religious liberty?
Well, it's not really a religious liberty case, although it affects that. This was simply an issue about whether the regulations put in place by the Trump administration that protect the ability of religious employers to not offer contraceptives that violate the religious beliefs, whether those regulations are acceptable. And the court said they are. It's a very different situation than where we were under the Obama administration when the regulations were not permitting religious liberty and the religious claimants were trying to overrule them.
Well, Ryan Anderson at the Heritage Foundation is predicting that a Democratic president in the White House would try and weaken or remove the Little Sisters regulation, and the case could be back in court again. Do you see it that way? Does this ruling just provide temporary relief for the Little Sisters?
Probably. It will probably get challenged regardless of the presidential election. They'll come back with another challenge saying that the rules are arbitrary, and we expect to see it back in the court again. If a Democrat wins the White House in the next election, I absolutely expect these regulations to change, to go back to something more like the Obama administration's rules that will much more limit the ability of religious ministries to get exemptions from the contraception mandate. So as long as we're dealing with regulations that can be changed, this can keep going back and forth.
Yeah. Well, in the Catholic school case, the court has ruled that employees of religious schools, hospitals, and social service centers cannot sue for employment discrimination. How important is this ruling for faith-based organizations?
This is an important ruling and a good one. It's consistent with prior law. There are actually two exemptions that Christian employers have, or any faith-based employer has, from employment discrimination laws. One is that you can always discriminate on the basis of your religious beliefs with any employee, even a housekeeping person who's cleaning bathrooms. You can say they have to share our religious beliefs. That's in the statute. This, however, is a constitutional exemption. They call it the ministerial exemption that the court has found out of the free exercise and non-establishment requirements of the First Amendment that says if you're dealing with someone who has ministerial duties or religious teaching duties, you can discriminate in any way. Essentially, they're saying the government has no business telling a Christian school, a church, a ministry, whom you hire to teach and promulgate your faith. And so this is a strong victory for ministries and churches and schools everywhere.